Roy speaking.
Mr. Roy, this is Hearing Officer Canny with the Oklahoma Employment Security Commission calling for the 8:15 unemployment hearing. If you could please hold while I dial the claimant.
Thank you. Hello?
Jeffrey Hayes, please.
Yep, you got him.
This is Hearing Officer Canny with the Oklahoma Employment Security Commission calling for the 8:15 unemployment hearing. I have the employer on the line currently. Mr. Roy, are you still connected?
Yes, I am.
Thank you. As I said, my name is Hearing Officer Canny, and I will be conducting the hearing today. Before we proceed, I need to advise both of you that this is an administrative hearing and that all testimony must be recorded and must be taken under oath or affirmation, and I am recording at this time. This is a hearing on Appeal Tribunal Docket number 14-9583, in which the claimant, Mr. Hayes, has appealed the Commission's determination denying unemployment benefits under the provisions of Title 40, Oklahoma Statute Section 2-406. This hearing is being held on June 17th, 2014 at 8:17 a.m. by telephone. Mr. Hayes, will you please state your name and mailing address?
My name is Jeffrey W. Hayes. My mailing address is 800 North 2nd, apartment H3 in Durant, Oklahoma, 74701.
Sir, do you have a representative or any other witnesses present today?
No.
Mr. Roy, will you be acting as the employer's representative?
Yes.
Your name and title, please.
First name is Rick, last name is Roy, Operations Manager.
The address I show for the employer's copy of my decision is 811 West Arkansas Street, Durant, Oklahoma, 74701. Is that correct?
It's 1811.
Okay. The address that appears on the notice of hearing is correct?
Yes, that is correct.
Are there any other witnesses for the employer today?
No, ma'am.
Do each of you swear or affirm any testimony you will provide today will be the truth, the whole truth, and nothing but the truth? Mr. Roy?
Yes.
And Mr. Hayes?
Affirmative, yes.
Before the hearing, a packet of documents was mailed to both parties in a manila envelope along with a booklet entitled Information for Appeal Hearings and Decisions. Mr. Hayes, did you receive the documents in the booklet?
Yes, I did.
And Mr. Roy, did the employer receive those documents in the booklet?
Yes, we did.
The documents that you both received are the commission file. Currently, none of those documents are part of today's hearing record. When I decide the case after today's hearing, I can only consider documents that are a part of the hearing record, as well as the testimony that we will take today. As we go through testimony, either of you can offer a document into the record during your testimony. You'll need to identify the document for me. The easiest way to do that is to use the page numbers printed in the lower right-hand corner of each page in the packet. If there is no page number, you can identify the document by describing its content. Tell me what it says, where it is in the documentation. I can find it that way. Once I've located the document, I will mark it as an exhibit, and then I will give the other party a chance to object to the document's entry into the hearing record. I'll then rule on whether the document should be admitted or not admitted into the record. Only documents that are relevant to the separation will be admitted into the record, so if I decide to keep a document out of the record, I will let you know and I will explain why. As I said, when I decide the case, I can only consider documents that are admitted into the record through the process I just described and the testimony taken today. Mr. Roy, do you have any questions about the document process?
No, ma'am.
Mr. Hayes, any questions?
I do have one. I got mailed some other documents on the 12th. I guess they were received, and I didn't receive until the 14th, so I sent an email to you in response to what I sent. Since on the email, it considered from whatever that you guys requested a clear copy of documents from the employee. And so I responded by sending a clear copy of my copy of the custody screening on-site thing.
I did receive additional documents from both parties. Those documents also are not part of the hearing record. If either party wants to offer anything into the record, you'll need to go through the process we described. I received quite a bit of additional documentation, so I don't know at this time if I have the document you're referring to. As we go through testimony, if you want to offer that document into the record, you can describe it and I'll find it as we go through testimony.
Oh, okay.
Any other questions, Mr. Hayes?
No, not this time.
At this time, I'm offering 3 documents into the hearing record. I'm offering these documents to show that an unemployment claim was filed, that an appeal was filed, and that we scheduled a hearing. These documents also demonstrate the legal authority under which we're holding today's hearing. I'm not offering the documents at this time for the content. I'm only offering them to show the path that the claim took to get here today. Appeal Tribunal Exhibit 1 is page 1 in the packet. That is the copy of the Notice of Determination sent to both parties May 28th. Appeal Tribunal Exhibit 2 is page 2 in the packet. That's the document of appeal created by the Commission when Mr. Hayes called over the phone on May 28th to file his appeal. And Appeal Tribunal Exhibit 3 is the Notice of Hearing. That was sent to both parties June 5th. That was the document that told you the date and time of today's hearing and the legal issues we'll be discussing today. Mr. Roy, are you familiar with those 3 documents?
Yes, ma'am.
Any objection to those documents being admitted into the hearing record for the jurisdictional purposes I described?
No.
Mr. Hayes, are you familiar with the 3 documents?
Okay, I'm looking at the Notice of Appeal, and that was page 1, correct?
Page 1 in the packet is the Notice of Determination. That's been marked as Appeal Tribunal Exhibit 1.
Okay, and that's one claim and all this, but, and then the second one is where I did it by telephone, and then the third document you're listing is done by Oklahoma Securities Commission, Carl, or whatever, appeal director, and it has on that Notice of Appeal, right? And it holds in there the email address, appellate division at OECF or
Well,
OEF.
yes, the third document was sent separately. It was the document that told you to call in today, told you the date and time of today's hearing.
Oh, okay.
Do you have any objection to those 3 documents being part of the record for the jurisdictional purposes?
No, I don't.
Those 3 documents are admitted into the record on my motion. The issue that's been appealed and that we will be considering is whether Mr. Hayes was discharged from his employment for reasons which amount to misconduct connected to the work pursuant to Title 40, Section 2-406. The Commission found that the employer initiated the separation and that Mr. Hayes became separated from his employment for reasons of misconduct. Benefits were accordingly denied. Since the Commission found that the employer initiated the separation, the employer has the burden of proof to establish that the claimant was discharged for misconduct. Since the employer has the burden of proof, we will start with testimony and evidence from the employer. As the representative, Mr. Roy will start the hearing with his own testimony as far as why Mr. Hayes no longer works for Eagle Suspension. At the end of his testimony, Mr. Hayes will have an opportunity to ask him questions about the testimony and about the separation in general. After the employer has presented all of its evidence and testimony, Mr. Hayes will have the opportunity to testify and present evidence. At the end of his testimony, Mr. Roy will have an opportunity to ask him questions, again, about the testimony and about the separation. I'll likely have questions for each of you during the hearing as well. And before we close the hearing, I will give you two the final opportunity to add anything additional. We do want to try to avoid taking irrelevant or repetitive testimony as we go through the hearing today. So if I redirect your testimony or ask you to explain how something is relevant to the separation, that is likely what I am trying to do. The only issue that I am considering today and I am limited to are the reasons for the separation from the employment. Mr. Hayes, do you have any questions about the procedure before we begin?
No.
Mr. Roy, any questions, Mr. Roy?
No, ma'am.
I do want to verify the dates of employment before we go to testimony. Mr. Roy, the commission file indicates that Mr. Hayes worked for the employer from May 26, 2013 until April 10, 2014. Are those dates correct?
My record showed 6/3/2013.
And what was Mr. Hayes' job title at the time of separation?
Team member.
Hayes, do you agree with the dates and job title just provided?
I was told by Russell I was considered in a position B because that's what I did, and that's what I was paying for. Yeah, I paid line 3 and was trained to feed line 3.
Okay. As I said, we'll start with Mr. Roy's testimony. Mr. Roy, tell me why Mr. Hayes no longer works for Eagle Suspensions.
During a random UA screening that was conducted at the facility, the results came back from Mr. Hayes' test that evening, and the results showed some elevated levels on the quick screen, and the sample was sent off for independent evaluation. So at that point, when it tests positive for quick screen, there is a determination of immediate suspension until pending final results from the MRO. Results came back conclusive positive tests. So our policy is that we terminate people who fail UAs.
You said a random UA screening. What does UA stand for?
Urine analysis.
And you said it was conducted at the facility.
On-site.
You mean, okay, at your facility at the job site?
Yes, ma'am.
And the test that was done at the facility indicated elevated levels. What does that mean?
I don't necessarily know all the details of how the quick screen actually processes and identifies, but we rely on those professionals to conduct those tests, and the quick screen showed that there was positive levels of a banned substance according to our policy.
You indicated that the sample was sent to somewhere else off-site for independent evaluation. Are the results of that evaluation in the packet somewhere?
Yes, ma'am. I will identify those and ask that they be submitted into evidence. Page 24. 25.
And I'll address them one at a time. Just one moment. 24 is not legible in my packet. Is there another copy of that document submitted? I know the employer submitted some additional information.
We requested the originals to have them, and I believe they were emailed to you.
I have a document from Lori Wright, June 12th, with the medical review officer report, drug test report, on-site custody and control. Is that what you're referring to?
Yes, ma'am.
Okay.
Those 3 documents. I'd like to submit those in as evidence.
Well, you had identified page 24. Is the document that says on-site custody and control form the same document that appears on page 24?
Yes, ma'am. The one on page 24 actually shows copy 2, which it didn't carbon through very well. So the original, which is copy 1, was the one that we had received and scanned and emailed to you.
Okay, I see what you're referring to. On 24 at the bottom of the page it says copy 2 collector, and then on the additional documents it says copy 1 original?
Yes.
Okay. Since copy 2 collector is not legible, I'm not going to admit that into the record, but I will mark the copy 1, which is in the supplemental information from the employer, as Employer's Exhibit 1. Mr. Hayes, do you have any objection to employers.
Yes, I do. I have an
Your
objection to that. Okay. I would like to refer to a copy in an email that I sent over the weekend. Let me bring that up. And it
Copy
shows a clear copy of my copy of this document. It's a JPEG copy, and it's of the document of on-site custody and control form 75296500.
I was just a few minutes ago handed what I think the email you're referring to, Mr. Hayes. It was received this morning. It's not your opportunity to offer documents at this time, so I'm not going to address that document now. You can offer that into the record during your testimony, sir.
Okay. Well, I'm going
if you want to.
Yeah.
And I understand that you were objecting to the document I marked as Employers Exhibit 1. The document you submitted, we can address, like I said, in your testimony.
Okay.
What's the nature of your objection to Employers Exhibit 1?
Well, I will show conclusive evidence upon my opportunity to admit documents on behalf of my case. And this document at the site was tampered with. It has what's known as after-the-fact comments made on it, which is a violation of the integrity of this document and is a violation of my civil right since it was tampered with.
Okay, and I understand that you dispute the document. And I'm going to overrule the objection since this is from Mr. Roy's testimony what the employer based their decision to separate from your employment. Am I correct, Mr. Roy, that this information was what was relied upon to discharge Mr. Hayes? Okay. So, Mr. Hayes, you'll be able to present that information later in the hearing, but since the employer's state of mind was based on this document, I'm going to go ahead and admit it into the record, overruling the objection. I had a few minutes ago said that I was not marking page 24 in the packet. Since based on some of the information I've heard, that sounds like Mr. Hayes is disputing some of the documentation. I'm going to go ahead and mark page 24 as Employers Exhibit 2 so that we can talk about it as well. This is the other copy, the copy 2 collector. Mr. Roy, since you offered that, I marked it as Employers Exhibit 2. Mr. Hayes, do you have any objection to that document being part of the record? That's page 22 and 24 in the record.
Well, I guess since you're going to overrule it anyway, no, not this time.
Field Tribunal Exhibit 2 is admitted. Mr. Roy, you'd identified some other documents in that additional...
Yes, page 25.
Okay.
The report from the medical review officer.
Okay. I'm marking page 25 in the packet as Employers Exhibit 3. Mr. Hayes, any objection to this document being part of the hearing record?
Yes, but I know it's going to be overruled. So.
What's the nature of your objection?
It is the same as the original, and when I get my chance to speak, I will say it.
Okay. Mr. Roy, was this document part of the employer's decision-making process to discharge Mr. Hayes?
Yes, it was.
Okay. I will go ahead and admit Employers Exhibit 3 into the hearing record. Was there another document, Mr. Roy?
Yes. I'd like to refer to pages 9 through 16 as the Eagle Suspensions, Inc. Employment Rules and Regulations, our drug-free workplace policy.
You said page 9 through
16.
I'm marking pages 9, 10, 11, 12, 13, 14, 15, and 16 as Employers Exhibit 4. Mr. Hayes, any objection to those pages being part of the hearing record?
No, not at this time.
Employers Exhibit 4 is admitted into the record. Mr. Roy, you had also mentioned in the supplemental information that the employer sent, the drug test report, you indicated you wanted to offer that as well.
Yes, ma'am.
What is that document?
I don't believe it's in the packet. It was emailed in the 3-page,
Yes, sir.
and it is the document with the header, ILER drug test report.
And what is this document? How is it different from the results? The on-site
We were provided it along with the original. I believe this is the form information that is collected prior to sending to the MRO.
I've marked that document as Employers Exhibit 5. Mr. Hayes, any objection to that document being part of the record?
Yes, I do. This was not part of the decision because I didn't receive a copy of this document till after, on the 12th. And I had already been unemployed before then.
Okay. Looks.
And it's repetitive evidence anyway, which I'm going to object to anyway.
Mr. Roy, when did the employer receive this particular document, the drug test report?
We received it when we requested, when we got all 3 pages together from the drug screening company.
When you say all 3 pages, you mean the medical officer?
The original, the original from ILER, it looks like they're standard, probably their database information, and then the MRO report. Those 3 came together.
Okay. And we've already established that that was the documentation that the employer based their decision on to discharge Mr. Hayes, so I'll overrule the objection and admit the drug test report as well.
Can I interject something?
An objection?
According to Mr. Roy, one of the documents as far as the originals were part of their determination on whether to terminate me at the time of, because I wasn't suspended, I was terminated at that point, and they did not have this
documentation. Sir, you will be able to
documentation.
testify in a moment.
Okay.
You have another objection to the drug test report, the document itself.
Yeah, as I stated, it was not part of their determination.
Okay.
on the
And I realize
decision.
that there may be a difference in testimony on that issue, but in order to complete the hearing record, I'm going to go ahead and overrule the objection and enter Employers Exhibit 5 into the record.
Okay.
Mr. Roy, was there anything else that you wanted to tell me at this time?
I don't believe so. I think that covers everything that I need to submit.
You mentioned random UA screening. How is the random group of individuals selected for the drug testing?
We have obviously an employee shift list, and we'll just choose names off the list. That's the whole purpose of it being random. And we've done the same process on day shift as well.
Do you do the drug testing in accordance with the standards for workplace testing?
Yes, ma'am.
Is there a chain of custody in the documentation, Mr. Roy?
I believe that it's Exhibit 1.
Okay. Is this the document that is Exhibit 1? Did this accompany the specimen when it went to the off-site facility?
Yes, ma'am.
Anything else you wanted to tell me at this time,
No, ma'am.
Mr. Roy?
That'll
Mr.
be
Hayes?
all.
Okay. Mr. Hayes, do you have any questions for Mr. Roy? You are limited to questions right now if you have any.
Well, actually, I can't ask Mr. Roy any questions because he was not present at the time of the screening.
You're not obligated to ask any questions. You just have the opportunity to if you want to.
Well, I could ask, well, did the company have an obligation to avoid discrimination by making sure that an equal number of parties of different races that are at the company were presented at the time of the screening?
Okay. Before you answer the question, Mr. Roy, Mr. Hayes, how is the race of the parties relevant to the separation?
Well, okay, let me just let that question slide.
Okay.
Let's go to the three documents that Mr. Roy stated that he based his decision, the company based their decision on. The original copy, that was evidence 1, or whatever, the one that says the original. The clear and original copy of the review and officer's report.
Go to your question, sir. Just go to your question, go to the documents.
Okay. Mr. Roy, these documents not being present at the time that I was terminated, I would like to know how you were to base your decision for my termination on these three documents.
Are you asking Mr. Roy if he had the documents at the time of the...
If he had them in his possession at the time of, because I wasn't suspended, I was terminated.
Mr. Roy, you need to let him answer the question, Mr. Hayes. Mr. Roy, did you have these documents in your possession at the time of termination?
We made the determination to terminate after Exhibit 3 was received.
And that is the MRO, the Medical Review Officer report?
That is correct. Obviously, Exhibit 1 came first. Then there was a period of suspension at that point until the Medical Review Officer report shows its findings. We don't terminate on quick screens.
Next question, Mr. Hayes.
Well, I was informed I'm no longer at the time of the screening that my employment opportunities or whatever.
Again, you'll be able to testify to that in a moment, Mr. Hayes, what you were told. Did you have any other questions for Mr. Roy?
Yeah, as far as, well, are you sure?
Mr. Hayes, Mr. Roy's already answered the questions that you've asked. Do you have any other questions, any additional questions?
Right, this time.
Mr. Roy, just for completion of the record, I'm looking at Employers Exhibit 3, and you indicated in your testimony there was a positive test per Employers Exhibit 3. What was the test positive for?
As shown on page, on Exhibit 3, it's elevated levels of amphetamines and methamphetamines.
To your knowledge, did Mr. Hayes challenge the results?
I'm not aware of anything.
Mr. Hayes, I just asked Mr. Roy for some additional testimony. Do you have any questions for him just on that additional testimony he provided?
No, because he just wasn't there. and I did challenge it.
And you'll, again, be able to testify to that in a moment. Mr. Roy, was there anything else from the employer before I turn to Mr. Hayes for his testimony?
No, ma'am, that will be all.
Okay. Mr. Hayes, you heard the employer's presentation as far as why you no longer work for the employer. Tell me what happened from your perspective.
Okay, what happened from my perspective is stated in my affidavit. This was emailed to you in a PDF folder or file. And it gives a full description of what happened at the time of the screening.
Did you want to offer that into the hearing record, sir?
Yes, I would like to.
I have, as I indicated, many documents, so you'll need to
Bringing it
tell
up
me
now
more
on my
specifically
computer.
what is in it.
Okay, if you bring up the PDF, well, okay. We have the first letter as the address. Waiting for it to come up. And then we'll go through where it has, I don't know what page number you represent it as. I'm showing it by affidavit of the UA screening, and I'm showing it as page number 5 out of 38.
Can you read some of it to me so that I can
Okay,
find it?
I clocked in at 6 p.m.
Okay.
on 4/10/2014.
I found it, and it looks like it's
Okay, there's 3 pages.
Okay.
Should be.
Mr.
Page 1, 2, and 3.
Mr. Hayes, I'm marking that document as Claimant's Exhibit 1. Mr. Roy, the document that Mr. Hayes is referring to was sent to the employer on June 10th. It was part of a email attachment received by my office on June 9th. Do you have that packet, Mr. Roy?
Yes, I do. The 3
Okay.
pages.
Yes, and the document at the top says my affidavit of the UA screening.
Yes.
I've marked that document as Claimant's Exhibit 1. Do you have any objection to that document being part of the record, Mr. Roy?
No.
And Claimant's Exhibit 1 is admitted. Mr. Hayes, and that document is part of the record. You don't need to read it. Tell me in your own words what happens revolving around the UA screening.
Okay, since we're just going to focus on just the discharge things, I noticed that at the time I'd given the male participant in the screening my sample, they were wearing the gray assembler's gloves that are given out to the assemblers at Eagle. These were not latex gloves, and anybody has basically, they're open anyway to do whatever they want. I noticed at the time he was doing my screening, he had stuck his forefinger inside my sample. And I objected to that, but that didn't go anywhere. And then, while talking to the female participant in the screening, she was trying to show me what the quick screen fit, and I kept telling her I cannot verify what you're saying because I can't possibly believe that I would test positive. If you let me get my glasses to where I can verify what, because over time, I can't see like real small print. So I wasn't allowed to visually verify at that time what the little quick screen said. And the only people that saw the quick screen was the female and the male sampler at the screening people at the time. And at that time, since I was objecting to the indication, since number one, I couldn't visually verify it on my own. Number two, they wouldn't allow somebody to go get my glasses for me, which were in the front holding area, to verify any of the readings, or allow me to whatever. I then objected and had it sent to the lab. And you'll notice in my statement, I say there stupidly without on a lab, but since I knew that if it tested positive after the stuff put a finger in it, and I know that these quick screening things are not 100%, and a lot of times they're not even 50%. I knew that at that time I had made a mistake, and as I stated in the thing, when I filed the claim initially, I did not know I could request a second type of test at that time, which I wouldn't have had done by then, because since the whole screening was handled incompetently, and people were allowed to stick their fingers in places and touch, I mean, the whole screening area was not sterile. There's no telling what could have showed up on anybody. And it wasn't secure. The area wasn't secure. I mean, as I stated in my testimony, after she poured it into the containers or vials to send them off to a lab, she had trouble keeping the stickers on there. And the samples, we all three walked, Russell, the female participant in the screening, and I both, all three of us, walked to Lori's office. And there was, as far as I know, nobody was there watching samples.
What happened after the quick screening was finished?
What happened after it is she explained to me that I tested positive. I objected to it, and then I refused to sign the paperwork because there's no way I could have tested positive. But I do know that you can, these things are triggered by, you know, all kinds of different things that we consume nowadays. Metabolically, our bodies are chemically different, so, you know, you could eat or ingest one thing and you test completely different than me. So, at that time, since I refused to sign the paperwork, she said that she couldn't send them off to the lab until I signed the paperwork. And at that time, I did sign the paperwork, so it would be sent to the lab. Then we walked straight to the office, Lori's office. At that time, she then mentioned that I had admitted, and I was flabbergasted, you know, about that. And I just stood there. I was just like, this is a bad nightmare. I need to go home. I mean, because I'd already been indicated at that point I was terminated. So there was no reason for me to
How do you know you were terminated at that point?
Because it's common knowledge, and that they don't even put anybody on suspension. They go by
at that time, did anyone tell you you were terminated?
Russell, when he dropped me off, and then when I called Lori and asked her if I had any more employment opportunities at that time, she said no.
When was the conversation with Lori?
It was after. It was like the next day. And it was that evening with Russell where I was informed that I was terminated.
I object to that.
On what grounds, sir?
That is not our policy, and those words were not stated.
And I do have your testimony, Mr. Roy, about the suspension, and I realize there may be hearsay testimony. I've taken hearsay testimony from both sides. We don't follow strict rules of evidence in these hearings, so I will overrule the objection, but noted that I do realize there is a difference in testimony on the issue. What happened after the quick screen, Mr. Hayes?
Okay.
You went into an office?
Went into Lori's office, HR office, and then I heard slanderous comments by the female, a statement that I didn't make, and then at that time, Russell offered to take me home. And at that time, he took me home.
Who is Russell?
The night plant manager.
What happened after that?
Well, after he dropped me off, I came home. I was still like dismayed that I tested positive for this thing. And I filed my case within a month after that because it wouldn't have made a difference because I was still going to receive a check and then still receive a check after that, but of work I'd already done. So,
Did you request a confirmation test at any point?
at the time of the screening, as I stated in my affidavit, nobody had offered it. Nobody had offered any kind of like rehab thing or anything. Nobody had offered anything at that point. At the time, after the female had stated that she stated her fraudulent statement to HR, it was already assumed at that point that guilty as charged, let's throw him to the street. At that point, it wouldn't have made a difference what I wanted.
Did you have any contact with the employer after that night when you were taken home by the plant manager?
After that, I was, after the initial conversation with Lori, when I asked if I had any employment opportunities still at Eagle, and was told no, after I tried to make contact with them again via the phone, all I got was voicemail after that. It was like I had a plague.
Did anyone ever contact you about the, either employer or anyone else, contact you about the results from the medical review officer report?
About a week and a half later, the so-called doctor asked me if I had amphetamines and as a prescription, and I told him no. Why would you? Because I already knew there was no way I should have tested positive anyway. But there are things in your urine that mimic and set these things off. And I figured out at this time, and I'll state later on why the objections that I might have on documents they submitted, that one hand washes the other in this. I mean, there's people's motives to keep their companies going, and all they have to do is stamp a piece of document or something, and that's it.
Tell me more about that conversation you had with the medical review officer, the doctor.
Well, after he said that, and I told him there was no way that I could have been positive, he said, well, we're showing through this that you are positive. And I'm like, there's no way. I mean, what kind of test did you do? And it seems like the more evidence I submitted against the testing, the more evidence they came up with confirming something off the original of what was given to them.
Did you talk to that medical review officer, that doctor, about a retest or a confirmation test, a second test of any kind?
It just hung up on me. He just stated that, thought it was kind of funny, didn't care, and just hung up.
Did you have any conversation about a second test?
No, it was never offered. Like I said, when I initially talked, at the time of the screening, I wasn't given the opportunity to take the second test. The only thing that it was offered to me was that it be sent to the lab, and that was it. And at that time, it didn't make a difference if they sent it to the lab or not. I was terminated at that moment. I wasn't given official suspension paper. Nothing was written up stating that you are suspended at this time due to a screening test and we're waiting. Nothing in writing was given to me stating that I was suspended. I was definitely knew that I had been terminated at that time, because I was not allowed to come back to work. I was not told I was suspended. I was told that I didn't have any more employment opportunities at the company because of the screening.
I realize that you object to the results, but I want to ask you some questions about some of the documents that were entered into the record. Specifically, Employers Exhibit 1, which is the on-site custody and control form. Under remarks, it says donor admits to use of MAMP/AMP April 4, 2014. Do you know what that's referencing?
That's more or less a cover-up because I did not say that to this person at all. This is not on my original copy of this document.
The original copy that you received, is that the document you wanted to offer into the record
Yeah,
earlier?
that is the document I wanted to offer. This
Or
is
is that
like,
in the packet?
that would be in an email to be a clearer document. And it does, in the, let me pull it up in my PDF file. Okay, that would be on page 10 of 38.
I don't have your page number, so you're going to need to...
Okay, it's the on-site, because it's after the screenshot of the Simply Safe website. It's...
Okay. I actually have, I think you're referring to what says copy 3 donor/employer. Is that what you're referring to?
Yeah.
Okay. I have 2 copies of those.
Well, one of them's cleaner than the other one, and it shows what I received off.
One I received this morning, and any documentation that comes within 5 days of the hearing generally isn't submitted because we need time to provide it to the other party. But that document was provided to the other, to the employer on June 10th.
You notice there are no remarks in my copy at all?
Hold on, I need to address the document before we talk too much about it. The copy 3 that I have that was received here on June 10th and sent to the employer on June 10th has a document that says signed while under duress. Is that the document you're referring to, Mr. Hayes?
That's the first one I submitted.
Okay. Since that was sent within the 5 days, I'll go ahead and mark that as claimant's Exhibit 2.
And if you need a clearer copy, the one email that you probably received.
Okay. I need to give Mr. Roy an opportunity to object, excuse me. Mr. Roy, in the packet that was sent to the employer June 10th, it's the same packet that claimant's Exhibit 1 is in.
Mm-hmm.
There's a document that says on-site custody and control form, copy 3, donor, employer at the bottom. I've marked that as claimant's Exhibit 2. Do you have any objection to that document being part of the hearing record, Mr. Roy?
Nope.
Okay. Claimant's Exhibit 2 is admitted into the record. Mr. Hayes, I did hear your testimony that you wanted to point out that the remarks section was blank, and you wanted to point out the difference in your copy versus the other document that was entered into the record, correct?
Correct.
Okay. Was there anything else you wanted to tell me about the reasons for the separation at this time, Mr. Hayes?
I believe I've covered everything as far as I wasn't given the second opportunity to test. The gun was jumped. I wasn't informed I was suspended by anybody, whether verbally or written. It was given through the car ride back with Russell. And the way I was treated in the office with Lori, and then the phone call I talked to her when we did talk, that I had no further employment opportunity.
What happened in the car ride back with the plant manager that made you believe you were no longer employed?
He pretty much was like, goodbye.
Didn't
We'll see you when we see you.
Were you told that you no longer had employment at that time?
It was referred to the conversation that we had, that unless a miracle happens, don't bother coming back. You know?
Did he say that to you?
It was implied. It was through the whole conversation. I was like, well, I guess I don't work here anymore. And he was like, pretty much.
And this was after the on-site screening?
After the on-site.
I just want to make sure I had the timeline correct. Mr. Roy, do you have any questions for Mr. Hayes?
No, ma'am.
We are moving towards closing the hearing. I did indicate I would give each side an opportunity to add anything additional before we close. before we do that, I wanted to just address something quickly. I have another hearing at 9:15. If for some reason we go over into the 9:15 hour, which may or may not happen, but in the event that we do, are both parties available today at 11:30 to reconvene if we need to?
Yes.
Okay. Is that Mr. Hayes?
Correct. I will be.
Mr. Roy?
If necessary, yes.
Okay. And again, that is only if we don't finish before that other hearing starts. Mr. Roy indicated he doesn't have any questions for Mr. Hayes. At this time, I'll go back to the employer. Mr. Roy, was there anything else the employer wanted to present or anything else you wanted to tell me before we move to closing?
No, ma'am.
Mr. Hayes, was there anything else that you wanted to tell me before
Yeah,
we
is this my opportunity now to object to evidence submitted by the employer?
You've already had the opportunity to object. The documents that were admitted into the record are part of the record, and you've admitted your documents as well. And I did hear in your testimony the objections that you had to their documents. And just
Yeah,
because one moment. Just because I've entered a document into the record doesn't mean I'm automatically adopting it as fact or as truth. It's just part of the entire picture for the hearing.
Okay, can I admit document that I sent through the email yesterday?
Sir.
That would be...
As I indicated, anything submitted within 5 days may not necessarily be admitted, but you can offer it if you can describe to me which one it is.
Okay, it was entered as, let me go through here, evidence cannot be used because of the tainted or contamination, and you don't know how far the deception goes. And it will list the 3 documents.
Is this the document that says Appeal Division at the top from Jeffrey Hayes, case number, subject, evidence tampered with and or tainted?
Yeah, I sent 2. I made an amendment to the second one because I object to where it says drug test report because it's a UA. It's not a drug test. It's a screening.
As I indicated, generally evidence needs to be admitted 5 days prior, but since Mr. Hayes has offered it, I will mark this as Claimant's Exhibit 3. Mr. Roy, this document was sent to the employer, but not until this morning. Do you have any objection to this document being part of the record?
I don't even know what I'm objecting to because
Okay. Since this was sent in late and we haven't had a chance to get it to the employer, I'm going to not admit the document. But Mr. Hayes, you've testified to most of the information that's in this document, so I do have your testimony on that. Was there anything else you wanted to address, sir?
Actually, if it was emailed to them, I'm sure they have time to bring it up. I would like to, if we can, give them a chance to see this document. I'd like to admit because it does hold pertinence.
And again, you've testified to most of it. It wasn't sent in within the time period required to enter it into the record, and I've ruled already on it. Was there something else you wanted to tell me? And if you wanted to tell me something that's in this document, just to provide your testimony, now's your opportunity to do that.
Okay, the reason why in this document that I wanted to have admitted is because when you take a look at the remarks that are section on their copy and my copy, it is stated in the law because of the severity of these screenings that everything has to be followed as to the letter of the law, procedure, and protocol with no exceptions allowed because of the repercussions, the severity of the repercussions. So that means these professionals that Rick Boyd stated that came in, any remark that is added to these documents must be signed off on to ensure that no after the fact or tampering has been done to these documents. Without signing off on these documents, the copy, the original that Rick Roy has presented, is deceiving in itself. As far as to the point, it looks like I signed this document with all these added remarks on it, which is a form of deception. It is a slanderous comment, and it violates and gives the employer the wrong impression that I had signed this document before this comment was made, which swayed their decision prematurely because they thought I confessed to something, which I did not, and you'll be able to tell that by looking at the difference of the two documents. We have here is tampering, evidence of tampering. There is no sign-off on it, and because this document was used, the on-site custody and control form 7529-6500 was used to obtain other documents, but by law, this is considered tainted, contaminated. The procedure and protocol was not followed in the
And you've already provided that testimony, sir, and I do have your affidavit as well in the record where you address that.
Okay.
Regarding
any other document cannot be, because we don't know how far the cover-up is going to go. By this Marla Gondel.
Mr. Roy, do you have any questions for Mr. Hayes on that additional testimony?
No.
Okay. I have one final question for Mr. Roy, and then we'll close the hearing. Mr. Roy, how was, from the employer's perspective, how was Mr. Hayes made aware that he was no longer employed?
He was contacted after the MRO report was submitted to us that he was terminated.
Do you know who contacted him?
I do not have that in front of me. I believe it was our HR office.
Mr. Hayes, I just asked Mr. Roy for some additional testimony. Any questions for him on that?
HR never called me. I had to initiate the calls with HR. I never received any letter, nothing via email.
Did you have any questions for Mr. Roy? I'll let you respond with testimony in a moment.
Okay, as far as contacted by HR, no, I was not. I had to contact HR.
And was that the conversation you already told me about?
Yeah.
Okay. Mr. Roy, do you have any questions for Mr. Hayes on that additional testimony he just provided?
No.
I am going to close the hearing at this time. I'll be mailing a copy of the decision to both parties in 10 to 14 days. If either side is dissatisfied with the outcome, they do have the right to appeal to the Board of Review within 10 calendar days from the day the decisions are mailed. Further details on the appeal process are included with the written decisions, so do make sure you read those in their entirety when you receive them. Since we've completed the hearing, we don't need to reconvene at 11:30. Mr. Roy, do you have any questions for me before we adjourn?
No, ma'am.
Mr. Hayes, any questions?
No, I guess not at this time.
Okay.
I am curious how. Never mind.
In that case, I thank you both for appearing today, and we are adjourned.
All right, thank you very much.